Hello, everyone. It's my distinct honor and pleasure to introduce today's speaker, Dr. Tyrell Haberkorn, who is Professor of Southeast Asia Studies in our very own Department of Asian Languages and Cultures. She's also an integral part of our Center's Faculty and Steering Committee, and is also the coordinator for the Center's Justice in Southeast Asia Lab. She also serves as the co-director for the Human Rights Program for the law school here, and holds many other service positions all across the campus. Prior to joining us at UW-Madison, she was Associate Professor of Political and Social Change at Australian National University. She holds a BA in Cultural Studies and Creative Writing from the University of North Carolina at Chapel Hill, and an MA and PhD in Sociocultural Anthropology, with minors in Southeast Asian History and Rural Sociology from Cornell. She is a political historian that has researched and taught across law, political science, anthropology, sociology, and comparative literature. Her research is concerned with state violence and dissident cultural politics in Thailand from the end of the absolute monarchy in 1932 until the present. As backdrop for her research and social justice interests, she first traveled to Thailand in 1997 to be part of International Feminist Labor Solidarity. And this became the foundation for decades of work across academic and activist lines to challenge state repression and other forms of injustice. Her work has been recognized and funded through awards from numerous institutions, such as Fulbright, Hayes, the Association for Asian Studies, Australian Research Council, the Einstein Forum, John Simon Guggenheim Foundation, and the National Endowment for the Arts, among others. She is one of the most prolific and productive colleagues that I have the privilege of knowing, and I suspect she does not get much sleep. Having just heard that you are part of an event this afternoon, I think it's just further data to support that conclusion. She has authored and co-authored, edited, and co-edited dozens of publications, far too many to list here, and has also translated many important pieces. I offer just a small sample to provide some inkling into her areas of intellectual productivity and expertise. She is the author of two major books, both published by UW-Wisconsin, UW Press. This first is In Plain Sight, Impunity in Human Rights in Thailand, published in 2018. The other is Revolution Interrupted, Farmers Studies, Law and Violence in Northern Thailand, published in 2011. And from what I understand, she has a new book manuscript currently under review entitled Dictatorship on Trial, Coups and the Future of Justice in Thailand. She has published in a variety of peer-reviewed venues, including Politics and Society, Journal of Asian Studies Review, and many others. She has authored several important book reviews and refereed book chapters as well. Titles include Under and Beyond the Law, Monarchy, Violence and History in Thailand, Justice After Dictatorship in Thailand. Moreover, she writes extensively for the general public, and as illustration is a piece that just came out this year in Dissent magazine entitled Starving for Justice in Thailand. If I had another 30 minutes, I might be able to fully relay the details of the CV, but we need to hear from her. And before I relinquish the floor, let me just say that she is such a wonderful colleague, and we are all very fortunate to have her here as part of our community. Today, she will be giving a lecture entitled A Jurisprudence Against Coups in Thailand. Please join me in welcoming her as our speaker.
Thank you for such a lovely introduction, Nam. I have to say I'm so happy to be here. And just as it surprises me greatly sometimes that I've spent most of, or at least half of the last 26 years in Thailand, I'm not sure how it's been 5 years since I've been here. Time passes unbelievably quickly when one is inspired and excited. And actually on sleep, I just have to say, I actually sleep a lot. I'm one of those people who, I'm an 8 to 9 hours a night kind of person. But I would actually say, part of why I can sleep is that one of my siblings takes care of my mother. So if I didn't have someone to help me out with the sort of familial caring tasks, then I would sleep a lot less. I always feel like I should acknowledge my sister for all that she does, actually, for all of her siblings. So in some ways, this talk is a little bit like how I spent my summer vacation, except it's more like how I spent the year and a half that I was on leave. So that is where it's coming from. With that in mind, I will go ahead and start. So actually, I want to start by saying that I never intended to write a book about the National Council for Peace and Order. and the 22 May 2014 coup. When the coup took place, Thailand's 13th since the end of absolute monarchy on the 24th of June 1932, I was completing In Plain Sight, which is a book on the history of impunity, or the inability and failure to secure accountability for state violence over, at that time, the last 90 years. And so beginning with the end of the absolute monarchy and ending with the NCPO's coup, in the book I trace arbitrary detention, torture, disappearance, extrajudicial killing, and the abuse of the law. And as I wrote, I learned that impunity is the foundation of state formation rather than an exceptional aberration. And although in the book I make this argument in the context of Thailand, I think you could make a very similar argument with almost any context. Once I finished the book, my plan was to write a political and social history of pork, pigs, not corruption, but actual pigs in Thailand, which was inspired by living near what I refer to as the pig corpse distribution point. However, since the coup, I've realized over the last 9 years that this is my When Politics Improve project. Increasingly, I'm starting to think there is no pig book in my lifetime. So it's sort of out there as like, this is what will happen if there's ever a meaningful transition to democracy. After the coup, like many people, my life turned towards raising the alarm about what was taking place under the NCPO. And in particular because, and I still remember the days of late May 2014 very, very starkly, because the immediate actions of the NCPO recalled the counterinsurgent regimes of the Cold War. So even though there had been a coup in 2006, the regime that followed after that coup in Thailand had made a very swift return to something approximating democracy. There were very few arrests, no political cases. But what happened, even just the first 2 days after this most recent coup, signaled a difference. So working with the lawyers and activists of Thai Lawyers for Human Rights, or TLHR, which was an organization founded on the evening of the coup to document the junta's rights violations and defend those targeted by the junta. I pilfered time from my day job as an academic, and actually I would say I really spent about 2 years only doing coup-related things, to translate reports, write brief analyses and op-eds, submit written testimony to the court in relevant cases, and do court observation whenever I could. I did so because many of those being targeted by the junta were my close friends and colleagues, but also because remaining motionless was not an option. Writing a book about the history of impunity for state violence as it arose again in the present, with my freedom safeguarded by my position as an academic and my US passport, would have been a contradiction too heavy to bear. So when the NCPO regime officially ended in July of 2019, after finally an election and the seating of a new cabinet, I decided to pick up chronologically where In Plain Sight concluded and write a history of law and justice under the NCPO. And so my talk today is about how I wrote this book and what it contains. So I'll start with its origins and then offer an overview of the whole book and then share brief versions of 2 chapters. So what would a history of the NCPO look like? How would one write it? What mode would one write it in? When the NCPO launched their coup, they promised to restore the rule of law after 10 years of political conflict, but their regime instead undermined its most fundamental principles. So actually they made 2 promises. They would restore the rule of law and they would bring happiness to the people. They didn't actually do either. Probably not surprising. Instead, they employed the arbitrary, disproportionate, and politicized use of the law to violate the rights of civilians, facilitate extrajudicial violence, and guarantee impunity for the coup and then subsequent crimes by state officials. Some of the ways this happened is that martial law, which provided authorities with broad powers of search and arrest, of detention, all sorts of a whole range of things, was enforced for the first 10 months of the regime. Civilian cases of crimes against the crown and state were placed within the military court system for the first half of the regime. Existing criminal law was used to target dissidents, criminalize their thoughts and actions, and create a general climate of fear. The most fearsome of these was Article 112, the measure of the criminal code that defines the crime of lèse majesty and stipulates the punishment of 3 to 15 years imprisonment per count, with 162 cases under the NCPO for things like having a conversation in a taxi cab, performing a theater play, writing graffiti in bathrooms, and the vast majority of cases for posts on social media, with each post counted as or determined to be one count. So for example, there is a person currently serving a sentence right now of 43 years, reduced from 86 because she confessed, because she shared a series of posts written by other people deemed to constitute lèse majesty during the coup. Despite the end of absolute monarchy in 1932, the monarch remains in an ambiguously powerful, elevated, and unquestionable position in the polity. This was even more so during the period of the NCPO, which held a transition from the former king, Bhumibol Rama IX, to his son, Rama X, or Vajiralongkorn, upon Bhumibhol's death in October of 2016. Alongside the abuse of existing law, the NCPO promulgated 557 executive orders that were given the status of law that authorized detention, re-education, and other violations. So as I noted, the NCPO officially ceased to exist in July 2019 following elections and the seating of a new cabinet. But the junta's influence remained in their legislative and policy legacies, not only these executive orders, which did not just automatically disappear when the regime was out of power, some are still in place, they have to be revoked individually, but also in the form of the constitution. Every new coup government in Thailand redrafts the constitution. They did this time as well. The 2017 constitution is one that creates, in a sense, a permanent place for the military, or semi-permanent place for the military in politics. So looking towards a possible transition to democracy and an accompanying accountability process, when I started thinking about this project in 2019, I planned to write in the form of a draft indictment categorizing the crimes of the junta in relation to Thai domestic, criminal, civil, administrative, and constitutional law, the very law they came to uphold and wish to restore. The NCPO's reliance on the law as a tool of direct repression or to frame extrajudicial violence means that a partial record of perpetrators and accounts of their actions exist in arrest records, interrogation transcripts, and court documents. Thai Lawyers for Human Rights, TLHR, archived these documents and allowed me to browse their files to gather evidence for the indictment. So just after the NCPO left power, between June and August of 2019, I spent those 3 months just in the TLHR offices reading their files. And as I did so, I was reminded of the intensity of the 5 years of the regime, in which nearly every day held an instance of arbitrary arrest and detention, or prosecution for peaceful expression, or another rights violation. But the more I read, the more insufficient and even incorrect a list of the junta's crimes came to seem as a history of this period. As I read, another story of law shined as primary, one of unrelenting struggle against the junta. TLHR lawyers raced to accompany those arrested by phalanxes of soldiers in the middle of the night, repeatedly submitted requests for bail, no matter how many times previous requests had been denied, and they recorded everything, including precise details of violence and intimidation conveyed by victims and families. On matters of both principle and procedure, TLHR held fast to an idea of the law as an instrument to protect people's rights and its application guided by an unshakable sense of equality. And this was in pretty stark contrast to the way in which the NCPO approached the law, which was to discard both principle and procedure. Neither applied, all the while they were claiming to uphold the law. So their work illustrated what Naura Erakat writes in the context of Palestine, that, quote, "The law is contingent and does not predetermine an outcome. It only promises the possibility of a contest over one." And what I thought about as I read their files and reflected on them in the months that followed, I realized that loss in the courtroom does not necessarily equate to failure in the struggle for justice. Unsuccessful legal battles, which bring people together around the aspiration of a new, different, and better society, are part of the long-term movement for justice by creating a community of solidarity and a shared memory of struggle for those within the broader community. Such struggles also perform the essential work of describing and making such a society imaginable in legal terms. So for example, every time an appeal for bail is written, even when lawyers know it's going to be denied, every time they draft that appeal, they are demonstrating how the law should be interpreted and what it should mean. And that act itself, regardless of how the court decides, I think does important work. So I decided to take a cue from the TLHR files to work out if and how the support of human rights and justice was possible within existing Thai law. What if the courts ruled arbitrary detention of dissidents to be illegal, rather than permitted for the protection of national security? What if even one judge offered fulsome support for the exercise of the right to peaceful demonstration against the junta, rather than casting it as sedition? What if the threat to human rights posed by detaining civilians on military bases was recognized as grave rather than inconsequential? So instead of enumerating the junta's crimes within Thai law, I decided to re-examine political and rights cases decided under the NCPO and propose new decisions. Rewriting judgments is a mode of writing history that examines the injustice that has taken place under the law while outlining possible alternatives that the dictatorship foreclosed. Sharing an orientation towards the future with drafting an indictment, rewriting judgments outlines what a just and fair jurisprudence could look like in a future in which human rights could not be swiftly pushed to the side each time a military junta launched a coup. Thinking of the Pig Project, even a future in which coups were impossible. I hope if I don't get to write it, I hope someone does. Many of you in the room are younger than I am, so you've got more years to wait for politics to get better. The pigs are waiting. So in rewriting decisions, I build on a method developed by feminist judgment projects. In 2006, a group of feminist legal scholars in Canada observed that decisions that bolstered gender injustice persisted despite fulsome legal protections in Canadian law. They decided to form a new court, the Women's Court of Canada, to assess why it was so difficult for the courts to treat women as equal members of the polity. And they selected 6 Supreme Court of Canada decisions and rewrote them. They discovered that the central problem in the decisions is that women's lives were elided, ignored, and decontextualized by the judges. In their new decisions, they wrote in the language and structure of actual decisions and composed new rulings using the evidence available and the law in force at the time of the original decisions. By working out new interpretations of the law and demonstrating that the existing decisions were only one possible interpretation among many, their work aimed to both bring equality to life, to show what it would look like, and also to demonstrate the legal viability of another, more just interpretation of the law. So instead of writing an article critiquing a decision, they took their critique, they created their critique by, in a sense, showing the gap between what is possible under the law and what existed under the law. So following the lead of the Canadian feminist legal scholars, similar projects have proliferated in the UK, the US, India, Australia, New Zealand, Northern Ireland, Scotland, and then international criminal and human rights courts. Rewriting unjust decisions is also a form of what Saidiya Hartman calls critical fabulation, in which she writes, quote, playing with and rearranging the basic elements of the story by representing the sequence of events in divergent stories and from contested points of view, jeopardizes the status of the event to displace the received or authorized account and to imagine what might have happened, or might have been said, or might have been done, unquote. Hartman does so in the context of the brutality of US slavery and its historical and historiographic erasure, quote, both to tell an impossible story and to amplify the impossibility of its telling, unquote. I decided to rewrite judgments to tell the impossible story of justice in Thailand nearly 90 years after the transformation from absolute to constitutional monarchy. And yet, is this possible? All of the existing feminist judgment projects have taken place in democracies with relatively equal and fair judicial processes in place. Gender equality and justice, the primary focus of the rewritten judgments, is accepted as a normative normative social good. Rewriting judgments made under a dictatorial junta in a country where the transition to democracy remains incomplete, as it is in Thailand, entails confronting history and reimagining the future in different ways. Thinking and working through the differences of rewriting judgments in and against a repressive regime productively extends the feminist judgment methodology into a new challenging context, one that could variously be called the democracy judgments, the anti-dictatorship judgments, or the people's judgments methodology. So and this was what I discovered through the process of rewriting, that when one rewrites judgments in the context of dictatorship, the possibilities and problems within the law are made particularly clear. The intertwined history of the law, the state, and monarchy in Thailand means that despite other options available in the law as it is written, courts overwhelmingly rule in favor of the state and against the people. And for anyone who's been in a Thai courtroom, the spatial layout of the courtroom reflects the hierarchy and apportionment of power within the law and its adjudication. Left largely unchanged by the transformation from absolute to constitutional monarchy in 1932, the Thai judiciary has long privileged the state over the people and the king over the constitution. Thongthai Winichakul laid bare the fiction of the existence of justice and the rule of law in Thailand and called for a new legal history. And that's the first image. He argued that two primary ideas comprise jurisprudence in Thailand: the legal privileged state and royalist rule of law. And he writes that the legal privileged state is, quote, a legal system that affords privilege to the state to violate private property and the rights and freedom of the people for public interest in law, both applicable to ordinary times and states of exception. The most important Thai public good is national security, and therefore the military is the entity that overwhelmingly enjoys and exercises this privilege, unquote. The royalist rule of law is the principle, quote, that holds that the king is above law and justice rather than the constitution or parliament that are held to be universal norms, unquote. And he argues that together these are both ingrained practice as well as uncontested legal history. To launch a coup, the violent upending of the existing regime without being held to account, quote, in his words, is a privilege of bandits and murderers that is endorsed by the judiciary. It is the collusion to commit the gravest crime that can arise in a given state, unquote. The legal privilege extended to the state reaches its height in the amnesty laws passed and the judicial approval given for coups, including that of the NCPO. So over the series of 13 successful, meaning that power was seized coups, beginning with 1932, the grave crime of the coup has become the primary mode of the relationship between the people and the state. The legality and the ability of the military, the monarchy, and other allied actors to overturn the existing regime when they choose to do so is produced and guaranteed by two actions. First, by the series of amnesty laws that have followed after each coup. Each amnesty turns the illegal act of rebellion into a legal administrative action. The second piece is that the Supreme Court crafted a practice of legitimation of coups beginning in 1949 through a series of 4 decisions about the 8 November 1947 coup. Together, the decisions and the amnesty laws form what legal scholar Somchai Richasilpagun calls, quote, the rule of coups, in which he argues that the repeated failure to hold coup leaders to account functions as encouragement for future would-be juntas to upend the constitutional order. And he calls this niti ratabahan, or the rule of coups, in a play on the Thai word for rule of law, niti lad. So, while not new, what I decided when I was working on this project, I concluded that although coups are not a new process, the range of rights abuses committed in the name of restoring the rule of law and the length of the NCPO's regime as the second longest dictatorship indicated a new level of impunity. This context, I think, both makes rewriting the judgments more urgent and in many ways more challenging in Thailand than in the democratic contexts of existing feminist judgment projects. So how did I do so? So crucially, the rewritten decisions in the book that I just finished differ from actual decisions in one crucial respect. Thai court decisions have the royal symbol of the Garuda at the top and are written in the name of the king. The court that I fantasize into being is a court for the people. Why did I choose that name? So to be clear, I am not Thai and I do not presume to write in the name of the people. But I write for the people in that I place the protection of the people rather than the elevation or the privileging of the state at the center of my analysis of cases and development of new jurisprudence. The Garuda is replaced at the top with a symbol of the democracy movement, so it's the 3-finger salute crafted into a gavel. And this was first used in a very colorful rainbow option as part of a queer feminist judgment rewriting project that I was part of last year, which I'd be happy to talk about in the Q&A. So rewriting judgments under the banner of an imagined court for the people is at once a political and analytic choice. The utopian move aims to both counter the overarching and ambiguous presence of the monarch in the polity and to center the people who are conspicuously absent from the decisions that I rewrite. So to give you a sense of the whole project, the book is comprised of 5 rewritten cases framed by substantive analysis of the original decisions. Chosen in consultation with TLHR, my selection of cases was guided by the goal to both highlight opposition to the regime and track the different ways that law was deployed by the junta to thwart it. All of the selected cases are those that are final, meaning that no more appeals are pending, and those in which the decisions are all already in the public domain. And I made that decision for a number of reasons. One is that way, if someone wants to disagree with what I've done, the evidence is all there for someone to write their own new decision. So I think sort of intellectually that makes sense. But the other reason is that I chose not to take up some of the most devastating cases to emerge under the NCPO, including torture and intimidation of defendants or victims, and any others in which the parties have asked activists and journalists not to report on their cases. They may be able to be taken up and discussed openly in the future. But my sense is that the role of scholarship is not to expose those who have experienced injustice and who would rather not be exposed. In reevaluating the cases and writing the new judgments, I draw on the records kept by Thai Lawyers for Human Rights, ILAW, Rachathai, and other human rights and independent media organizations, court, police, and military documents, and my own court observation. One of the things I realized, actually only when I went to rewrite the decisions, is that every decision under the NCPO, no matter whether seemingly about joining a political protest, not answering a summons to report, or opposing the draft constitution, was also a decision, and not also, but primarily, a decision about the legitimacy of the 22 May 2014 coup specifically, and coups as a mode of rule generally. Each of the chapters is framed through a pair of ideas, what I call the existing jurisprudence of impunity and a possible jurisprudence of accountability. The jurisprudence of impunity emerges across the indictments and judgments rendered during the NCPO years, and it's characterized by the denial of the people's right to participate in the polity, a centering of the military and the monarchy as unquestionable, and disproportionate punishment for dissent. And just to note, in ruling against the people in the name of the law, judges under the NCPO both acted resonantly with judges under other authoritarian rule by law regimes around the world, and they also built upon existing legal practice in Thailand. But this isn't the only possibility. If one begins by privileging the people and recognizing dissent as protected under both Thai domestic law and Thailand's international human rights obligations as it is, different narratives and divergent outcomes become possible. So what I cast as a jurisprudence of accountability, which is one that values and centers rather than erases the participation of the people in the polity, holds state officials and institutions to account, and treats justice itself as an ideal to strive towards, can be imagined and created. So one of the ways to understand the 5 decisions in the book, 4 of which were decided in favor of the junta, is as a part of the history of the NCPO's repression. But they're also a record of how citizens held the line against dictatorship, despite the sacrifices that this entailed. So, ordered chronologically, the first case rewritten is one brought by citizens against the junta for launching the coup. The next 3 are cases in which citizens were punished for non-compliance with the junta, including a citizen prosecuted for peaceful protest, citizens prosecuted for not reporting when summoned for detention and re-education, and then a citizen punished for tearing his referendum ballot in protest of the illegitimacy of the draft constitution. And then the final case is one brought by a citizen against the junta in the administrative court with regard to the detention of civilians on military bases. So the way the book is structured is that there is a substantive narrative chapter about the case and the broader context, and then the actual rewritten decision. So in the rewritten decisions, I've taken on the fundamental instructions and guidelines of the feminist judgment projects. I draft judgments in the narrative form used by judges in Thailand and by drawing on the same laws in place under the NCPO. And just as a methodological note, the way I did this is that I drafted them first in English, then I translated them into Thai, and then I asked lawyer colleagues to read the Thai versions and critique them, and then I revise the English versions that are in the book on that basis. So I rewrite the decisions using the same bodies of law used by Thai judges. So I don't make up new law, I don't discount existing law. The 5 rewritten cases were originally decided by the Civilian, Criminal Appeal, and Supreme Courts, the Military Court, the Administrative Court, and the Constitutional Court. So each of these courts has a slightly different narrative style, so I aim to use the same form that they used. So like the feminist judgment projects, my goal was to write judgments that would be believable. So what I discovered is that rather than women being missing, the people are missing. So for example, the names of the 16 plaintiffs, let alone the significant damages they suffered as a result of the coup by those who brought the case against the junta, are left out. The reasons why people chose to protest are left out. The detention of a man's children and also his 9-month-old grandchild on a military base until the authorities apprehended him and took him for re-education are left out. The surveillance of activists by military intelligence so that they could be arrested prior to even reaching a demonstration are left out. What I learned is that by rewriting the people into the decisions, that simple action makes other decisions possible. So the new decisions attempt to do a few different things. First, to interrogate the lawfulness of the coup within the history of pro-coup jurisprudence in Thailand. Second, fulsomely consider the meaning of sovereignty. The original decisions all identify the NCPO as the sovereign on the basis that the junta was able to capture state power. And instead, the new decisions attempt to reflect on how to make real in both the exercise and the interpretation of the law the promise in nearly every constitution since 1932 that the highest power in the land belongs to the people. Third, the rewritten decisions aim to show the many different ways in which the judicial process and judgments themselves can aid in the protection of rights rather than facilitating their violation. And then fourth, each of the decisions and the broader discussion of their context takes up the status, the meaning, and form of the law as experienced under the NCPO and contributes to examining the contest over the law and its outcome that Nora Erakat so eloquently foregrounds. The epilogue concludes with a reflection on cases that can't be rewritten, Lèse Majesty cases, which I'm happy to talk about in the Q&A. So I just want to talk briefly about the two of the decisions, and I have paper copies of both. I know death of a lot of trees, but I didn't want to use a QR code because I don't actually want people not in this room to have access to the unwritten decisions, so I apologize for the trees. But so,
Are you saying don't share these though either?
yeah, please don't. I mean, it's fine if I just don't want them online anywhere. Is my at this stage. So the first chapter is about the only case against a junta for launching a coup that has ever made it to the Supreme Court. On the first anniversary of the coup in May 2015, Resistant Citizen, a coalition of 16 activists, lawyers, artists, and survivors of state violence, filed charges of treason and rebellion against the NCPO. This is significant because, as I noted earlier, after the 1947 coup, 4 cases related to the coup made it to the Supreme Court. In none of these cases was the coup the central problem, but the court ruled on it in relation to other issues. In every one of these decisions, the Supreme Court both affirmed the validity of the amnesty laws that the coup regimes had wisely passed, but they also said that even though coups were illegal when they occurred, once the junta was able to capture state power, the junta then became the legitimate sovereign. And just as an intriguing intellectual history note, this is a borrowing of an idea of coup jurisprudence that has been used by many courts sort of around the world, beginning with Pakistan in '58. It's an idea that court judges have repeatedly taken up to justify coups. They're borrowing from German jurist Hans Kelsen's idea of revolutionary legality, which of course was never meant to be used in practice, but it has been taken up by practice. The Thai Supreme Court never cites Kelsen. And Sasipa Buksarachan, who's a lecturer at Thammasat in the Faculty of Law, wrote an MA thesis, which is now a book, where she discusses this, and she says the fascinating thing about these decisions is even though this idea is identical to Kelsen, and some people have speculated that Thai Supreme Court judges, some had actually studied in Berlin with Kelsen when he was still teaching, that maybe that's where they learned it. But Sasipad concludes that she doesn't actually think so. She doesn't think this is a case of plagiarism, but instead, Kelsen's idea actually maps onto existing ideas of legal philosophy in Thailand. And if you think about Thongchai's characterization of the legal privilege of the state, it makes sense. In a sense, they didn't need to read Kelsen. So despite the amnesty laws passed with each coup to foreclose accountability, the 2014 coup, of course, as well, Resistant Citizen advanced an idea of the people's sovereignty that refused its destruction by an illegal seizure of power by a handful of military generals. What they do that I think is so brilliant and quite moving is that They create a new idea of sovereignty belonging to the people in the very way in which they frame their case, explaining in their petition to charge, and so I'll just read the English translation of the Thai, which is they write that, quote, even the civil servants whose salary comes from the taxes of the people were not courageous enough to stand up to the power that emerged from the barrel of a gun. It was only the people, the citizens, who dared to courageously rise up to oppose the dictatorial power of the junta, as has been seen from the past until the present. So by articulating a history of people's struggles against coups and joining this struggle, resistant citizens refused the erasure of the people, both necessitated and produced by coups. In this case, too, the Supreme Court adhered to historical precedent and dismissed resistant citizens' charges against the NCPO. In contrast, a jurisprudence of accountability would center the people and accord weight to the damage sustained by individuals and the polity by coups. So the new decision by the Court for the People, which you have, sketches how a court might respond to the upending of the constitutional order in a manner that honors the history of people's opposition to coups and accounts for how they are impacted by them. And so the decision that I write reverses precedent and writes towards a different future in which sovereignty is not reduced to brute force, but is in fact a shared project between the rulers and the ruled. So the second chapter takes up the first peaceful protest case after the junta, and actually, I just have to say, I remember, so Australia is 4 hours ahead of Bangkok. I was living in Australia at the time, and I watched this arrest live as it happened. It was 10 o'clock on a Friday evening, and actually there were several of us who were monitoring things happening related to the coup, and we all watched. So one day after the coup, on the 23rd of May 2014, Apichat Pongsawat, a recent law graduate, joined a protest against the coup, and he's this person holding up the A4 piece of paper. And his sign says, quote, "I do not accept illegitimate power." And he joined several hundred people who were massed in front of the Bangkok Art and Culture Center in the center of the city. Upon seeing his sign, heavily armed officers swiftly arrested him and detained him incommunicado on a military base. The second chapter traces his 4.5-year fight against what first began as 6 criminal charges across the Court of First Instance, the Appeal Court, and the Supreme Court. His protest of the coup and his persistent refusal to cede that it was a crime reflects the clarity of one citizen's commitment to the Constitution. The court's steadfast judgment of him as guilty, even after the junta order under which his protest was criminalized had been revoked, instead reflects the judiciary's unwillingness to protect the Constitution or the rights of a citizen willing to sacrifice his freedom to do so. And in a particularly sort of ironic moment, the Thai courts move really slowly, the Supreme Court especially so. And so the Supreme Court decision in this case came 5 years after, actually more than 5 years after he protested. It was in August of 2019. And I was in the court on the day it was supposed to be read. And at that point, the law under which his protest had been criminalized had already long since been revoked because the junta revoked the law prohibiting public protest before the election so that their party could campaign. However, so the judge, there were only 2 observers in the courtroom that day. You know, it was long after sort of the really intense moments of many political cases. So there were just 2 of us plus his lawyer and Apichat, and the judge started reading the Supreme Court decision. And there's often a gap too between when the Supreme Court makes their ruling, which is all written, and then it gets sent to a lower court to be read. So the person reading it is not actually the person who wrote it in Thailand. So there had been a gap between March and August, but actually even by March, the law was no longer, that he was charged under was no longer the law. So the case should have just been dismissed. That's what happens when in the Thai criminal procedure code, if there's no longer, if you're accused under a law that is no longer a law, your case disappears, as you would imagine. So the judge is reading and the lawyer raises her hand and says, "Excuse me, that law doesn't exist anymore." The judge looked perplexed and she said, "You know what, you're right, this is a problem." She said, what we're going to do is I'm going to fold up this decision, put it back in the envelope, because it comes sealed to the lower court, and then the judge unseals it in front of people. So I'm going to send it back with a note and say they should probably look at this again. The Supreme Court ruled again 4 months later. They still convicted him under the law that didn't exist. So, and they asked that initial decision not be, and that sort of embarrassing moment not be reported. Of course, it was reported and recorded well. I'm glad to have participated in doing so. So the new decision by the court for the people instead finds Abhijit innocent, develops a logic for how his actions of peaceful protest were protected by both domestic and international law, and clarifies the role of the judiciary in protecting the Constitution. And so as he explained the night before the first decision, in English it's that, quote, "The entirety of this is the path of struggle that I have chosen. Just as I chose to come out to oppose the coup, I choose not to turn away from entering the judicial process. This is a challenge to our lives and the principles of law, and to the true democratic ideal to which we should aim. I think it is what one should do for society," unquote. I want to end with his words because I think that this too is what scholarship should do for society. So I will end there, and those are the two decisions that you have if you want to see. I thought about doing what judges do, which is they read them out actually sort of usually in this really fast, low voice, but it would take way too much time. So thank you so much.